The idea of today's webinar is to exchange views on the exceptional COVID-19 situation that we are living, to see how the BAT guidelines are being perceived by the different stakeholders of the international basketball community, to see how this is being lived on the field, so to speak, and obviously to address any questions that we could have at the end of our discussion. First of all, we will have a brief summary of the guidelines presented by my colleague Wouter Janssens. Then we will tackle the impact of COVID-19 for the different stakeholders herewith represented, what it means for their organization, for their club, their player, their championship, to have a brief assessment on that. We'll have then a roundtable on the origin, the reasons, and the impact of the guidelines and how it affects discussions between those stakeholders. And finally, we will also briefly tackle the issue of the 2021 contracts, which are in theory and technically not part of the guidelines as they have been drafted by the BAT, but which of course also call for a lot of questions. Today we have a very nice panel for you to address those topics. First and foremost, we have Heiner Kahlert from the BAT, who is an attorney partner with Martens Rechtsanwälte. You all obviously know the law firm and the BAT, the law firm that operates the BAT. You all know Mr. Kahlert, and his presence here today will be very obviously of high value. Second, we have Mr. Benjamin Schindler of FIBA, Legal Affairs Manager of FIBA, who will address the issue of the enforcement of the BAT awards. Mr. Schindler is not here as a spokesperson of FIBA to talk about the policy, to talk about the guidelines, but is here in his role that is known to you with respect to the enforcement of BAT awards, and he will also address a few words to us in that respect. Third of all, we have the honor and the pleasure to have a club representative here with us today. The club is a EuroLeague club, is Alba Berlin, and we have the honor to have its sports director, Mr. Himar Ojeda Pérez, present with us. For people not knowing Mr. Ojeda Pérez, but I doubt there are any, Mr. Ojeda is a Spanish citizen, originally from Gran Canaria, has been a youth coach, has been an assistant coach, has been a sports director with the team of Gran Canaria, then with the team of Estudiantes, has then briefly also worked for a renowned international sports agency, was director of international scouting with the Atlanta Hawks in the NBA, and finally was recruited by Alba Berlin 4 years ago as a GM. As a player and agent representative, we have the pleasure to welcome today Mr. Stefano Meller, who is an Italian citizen and will also be able to tell us about the situation in his country. But obviously we have Mr. Meller here because he is a long-standing agent in European basketball, both at the highest level with players in the EuroLeague, as well as in all major and less big championships in Europe. So an agent with a very large experience who covers actually the entire spectrum of international basketball, and is very well placed to give his opinion on the impact of COVID. And last and finally, I have the pleasure to introduce my colleague Wouter Janssens of CRESTA, a partner at CRESTA. Wouter holds a law degree from the University of Leuven, holds also a degree in applied economics of the University of Leuven, and has been an assistant professor with that university, but first and foremost is one of our partners at the firm in CRESTA who deals, I would say, almost on a daily basis with BAT cases. I have spoken enough. I'm giving the floor now to Wouter to briefly address and summarize the guidelines of the BAT as issued in the course of last April. Thank you.
Thank you, Sébastien, for giving me the floor, and welcome to all panel members and participants to this webinar. I will try to give you an overview of the guidelines issued by the BAT in 5 questions. The first question: when do the guidelines apply? First of all, the guidelines are only relevant if the underlying contract contains a BAT clause. If there is no BAT clause, the BAT cannot handle the case. However, it's not necessary that the standard BAT clause is used. In a recent case, even the mere reference to FIBA was accepted. Second, the guidelines applies to contracts between clubs and players or coaches. The contracts between clubs and agents are less clear. However, it is announced that the same principles would apply, although we know that the dynamics could be quite different. Third, the guidelines only apply to contracts that were concluded before the suspension or termination of the championship. If a contract was concluded or an option was lifted afterwards, the impact of the crisis should have been taken into consideration when negotiating the deal. Second question: what do the guidelines say? Well, they make a couple of things clear. On the one hand, the concept of fully guaranteed no-cut contracts is abandoned. Players and coaches cannot claim 100, so as to say. On the other hand, contracts are not annulled and cannot be terminated for just cause following the crisis. Clubs cannot pay 0. Instead, the guidelines introduce a so-called duty to renegotiate in good faith, to end up somewhere in between. And actually, 2 things can happen with renegotiations. Ideally, an amicable solution is reached, a settlement is signed, and the dispute is solved. However, it is possible that clubs do not honor their payment obligations under such settlement. If players would then start BAT proceedings, the BAT will stick to what has been renegotiated. Pacta sunt servanda. Of course, it's also possible that no amicable solution can be found in the first place. If players would then go to the BAT, the reduction mechanism under the guidelines comes into place. So actually, the guidelines instigate the parties to enter into amicable negotiations, and at the same time influence the outcome of such negotiations by setting the default option. Third question, maybe the most important one: how much reduction? First, the salaries. Monthly salaries are reduced up to 20% of the first €2,500 net that a player is making or a coach is making. Above €2,500 net, the reduction would be 50%. So, for instance, if a player makes €2,500 under a contract, the BAT would grant €2,000, being 80% of the initial value. But this percentage decreases quickly. €5,000 becomes €3,250, being 65%. €100,000 becomes €50,750, being nearly 50%. Now, it's important to note that this is not a fixed system. It is possible that the BAT would reduce with less than 20% or more than 50%, depending on the circumstances of a particular case. As you know, the BAT decides ex aequo et bono based upon justice and fairness. As such, the BAT could consider, for instance, things like the overall amount of the salary, the financial situation of the club as a result of the crisis, the individual situation of the player or the coach, the club's behavior towards other players or coaches, and the way the club will use the money that it saved through the salary reduction. I will come back to you later with some recommendations on how to handle these elements in preparation or inside of BAT proceedings. Another element are the bonuses. It's quite straightforward that no performance bonuses are granted if no games are played. Ranking bonuses would not apply unless the championship would still be complete. Finally, there are the amenities like car, apartments, flights, catering, health insurance. They logically stay in place as long as the players and the coaches are effectively using them in good faith. Fourth question, anything else? Well, yes. The guidelines also have an impact on disputes that already existed before the crisis. Overdue payables and termination indemnities dating back before the suspension or termination of the season remain 100% due. However, a grace period is introduced for clubs that would otherwise face the risk of insolvency. This means that up to 50% of salary payments can be shifted to the start of next season. For bonuses, this is even up to 100%. Second, the guidelines also have an impact if competitions would restart to complete the current season. Salaries would have to be reduced, even though the sporting obligations of players and coaches are no longer suspended. Moreover, if the completion of the current season would go beyond the original end date, contracts would remain in force until the date of completion. Final question. Guidelines. So what? The guidelines only establish abstract principles. They are not binding for the BAT arbitrators, who can make exceptions depending on the circumstances of a particular case. This actually means that we will only know for sure how the BAT is effectively going to implement these guidelines once the first awards are being published on the topic. Unless, of course, Mr. Kahlert can divulge some of this later. Sébastien, I return the floor to you.
Thank you, Wouter. I think that was a clear and brief summary on the guidelines that most of you probably have already read. Before we tackle, I would say, the origin, the reasons and the impact of the guidelines, I maybe would like to hear from each of the stakeholders how they have been feeling or living the impact of COVID-19. And maybe I could start with Himar.
Okay, so hello everyone. I would say that this is a difficult time for everyone, and it's a difficult time for our organizations. And I think everyone is aware that this is a difficult time for every organization probably in the world, almost everyone, not just in the sport business, but in the regular life. As a club, received the situation as a shock, like everyone else, and we need to stop, or we stopped since the first day any activities. We approach our players and our employees, and we basically allowed them to return to their places if they consider that this is what they wanted to do. Because we understand that in these difficult times, despite the environment that our players and coaches have here, it's pretty secure. So we understand that in these difficult times, they want to stay in a place where they feel probably close to the family or close to the roots. So this is what we did since the first day. Other than that, we're trying to basically handle the whole situation in different aspects, the sportist aspect, to see if there's possibility to resume the league or not. And this is a decision that has to be made by the authorities. And second, financially. Okay, so we have a club that have a business model that is based basically in what we can generate. So we depend on our ticketing selling, we depend on our marketing activities, we depend on our sponsors. Okay, so that's the reason that we have been hit really high, because or really strong, because all these incomes are gone in one day to the other. Okay, so we try to stay calm and try to look for possible solutions and try to analyze the situation, try to not speculate, because I think everyone is realizing that this is a situation that is difficult and is new. And sometimes even governments are making an announcement that they need to change after a couple of days. So we want to try to have a good communication with all the people around us involved, our sponsors, our players, the agents, all the workers. So try to have a good communication, try to update with the news that we have, and try to take the right measurements in order to pass this situation and this crisis. And this is what we are focusing now.
Okay, Himar, can you brief us on the latest update? When do you expect there to be a decision with respect to the competition, both 1920, because unless I'm wrong, I think it's not been decided, and then obviously maybe also with respect to 2021?
Yeah, well, the BBL, or the German league, decided at the very beginning to keep the same philosophy. We will try to postpone, let's say, definitive decisions. And a week ago, a little bit more than a week ago, the league decided to try to present a project of a tournament to finish the season. Why this? Because the possibilities, let's say, in our environment in Germany are, let's say, pretty optimistic that this is a real chance, a real possibility, always considering that it will be something that is safe for everyone. Okay, for all of us that are involved, that is safe. So once the league approved that, we have been working to prepare a format and to prepare a concept to present to the authorities, because at the end it's going to be the German government or the local and the general authorities who will approve the option to play or not play. This is happening right now. We will present this in tomorrow, and we will have an answer that is going to be, I mean, not the day after, but we hope pretty quick, because there's a situation with the football here with the league that is also happening. They will have an answer tomorrow to resume the league, and this is the path that we are following.
Okay, maybe one final question, if you can address it. How have the talks with players and coaches been going on so far? Did you do it on an individual base? Was it done collectively? And where do you stand, if you can mention something about it today?
Well, so something that we stick on is, since the beginning, is like with the idea or our concept that we believe this is not a problem of Alba Berlin. This is not a problem of our players. This is a global and a common problem and situation. So we stick with the idea that the more we can work together and try to look for a solution, it will be the better. Okay, so we wanted to wait because we are not only participating in the BBL but also in the EuroLeague to see if we have like common agreements or guidelines, not only within these two competitions but in the basketball in general, in order to address these situations with the players. Since there was an agreement within the EuroLeague and the Players Association to present a project, okay, that how to more or less solve this difficult situation financially for the clubs. We stick with the idea to wait, and once that happened, we are addressing this situation with our players, but always as a group. So we said since the very beginning that we don't think there's considerations to individual agreements in our particular situation. It's not that we are against that. We think in our particular situations, since we are, let's say, pretty equal in terms of the situation with the players, okay, and with the agents and with the payments and everything like that. We want to address that as a group, and our proposal to the players is as a group.
Okay, and all of that is assuming that you will have a possibility to resume, if I understand.
Yeah, well, we're addressing the two different situations. If we are able to resume one of the competitions or both competitions, or if we are not able to resume any of the competitions.
Okay, thank you, Himar. Stefano, perhaps, yeah, we won't ask how the situation is in Italy, but yeah, you're, I guess, best placed to give us some input on the impact on Italian basketball.
Well, yeah, thank you for inviting me, allowing me to leave my house where I've been secluded for almost 2 months first. That's the most important thing. So being able to come back to my office. Well, the situation has been devastating, not only in Italy, but actually everywhere, talking about basketball. In Italy, the impact has been tremendous. I live in Milano. We are basically the worst place in the world right now. We had so many deaths and infected people, and slowly the situation seems getting better. Since yesterday, about 4 million people in Italy started going back to work, but when you go around the city, it's still a ghost city with very few people around. The impact has been, as I said, devastating everywhere, with different situations, because every country has handled the situation in a different way. Every league has handled it in a different way, which has been the most difficult thing for us to handle, because we had to face not just a unique guideline or unique direction, but so many different ones. Right after the explosion of the pandemic, the majority of the leagues have been suspended, but some of the leagues immediately have been canceled. And we were absolutely clueless on how to handle these different situations. Italy has suspended the league and has canceled the league about a month later or more, 5 weeks later. Other countries, Belgium, for instance, the day the government announced the lockdown, has canceled the league, and other countries did the same. So we had a tremendous impact on every situations. All contracts, all payments have been put on hold, waiting to understand what would have happened. And the situation has been going on this way for weeks now, and we are still in many countries with not clear situation, not clear at all. This, I think, was the most difficult aspect for people doing my work, because every country has different laws, every country had different agreements, every country decided to handle the situation in a different way. And not only inside every league, teams have been doing different things. So we had a really devastating impact, players waiting for payments, having no ideas what to do. We also had to deal with foreign players that wanted to leave the countries, to go back to their residency, to their home countries, to join their family. And we had to face situation with teams that did not allow them to do this without giving us specific directions. So it's been, this 2 months have been very, very difficult.
Okay, thank you. Sorry.
Okay.
We'll get back to you once we talk about the impact of the guidelines. Maybe I can shift now to Heiner Kahlert with BAT, and to hear how the crisis has been affecting the working of the BAT.
Thank you very much. First of all, obviously for the invitation and for hosting the webinar, which I think was a great initiative, and the number of participants seems to confirm that there's a great interest in the market to discuss about these issues. So I think that's a very good idea to have this webinar. I think on this point, the impact that the crisis had on the BAT, I can be relatively brief because, to be quite honest, the impact was not that heavy for us as an institution, that is, because I think most of it we set out already in this information notice that we published in mid-March. Of course, everybody here as well, like elsewhere in the world, everybody is working from home, but since we have been working electronically since the very beginning, it doesn't really affect much the operations of the BAT as an institution. We have a platform, for example, where every arbitrator can access online quite easily all the cases. So it doesn't make a lot of a difference whether the arbitrator is sitting in his or her office or at home. Similarly, the communication that the institution has with the parties has not really changed that much, because it has been electronic for many, many years. In particular, we have always accepted submissions as PDF only, filed by email only. So compared to some other courts, we didn't need to change our practice in any way. The communication is still the same. I think the only two impacts that we do see, first of all, this will not surprise you, we are seeing more requests for extensions. However, as set out already in this information notice, there's not an automatic mechanism whereby you just raise a flag, say Corona, and then you will receive whatever extension you're asking for. Rather, basically the same principles apply as before. If you ask for an extension, you need to give specific reasons why you are asking for an extension. And obviously, depending on where in the world you are and what the impact of the crisis are, there are very good chances you are going to get an extension, but you still need to specify what exactly is the situation in your country, why does that prevent you, even though you're probably working from home, to make the submission within the time limit that was set. So that's the first impact we are seeing, but I should say, even though we are seeing additional or a higher number of requests for extensions, it's not systematic. It's not like in all cases, all of a sudden we see delays. Actually, we would have expected this to be more prevalent, but I think at the moment we're not really seeing that much of a delay in many cases. So that's the first impact that I would say we've seen so far. And the other is Also, that is not very surprising for those cases where we cannot deliver documents by email because either we don't have an email address, or the emails bounce back, or we just don't get a read receipt where we need confirmation that the document was delivered, in particular for the arbitral award. We have encountered difficulties in some countries to deliver couriers. Why? Quite simply because in those countries or areas of certain countries, the courier companies don't operate anymore due to Corona. And that obviously is a problem, which however will be a temporary problem because hopefully very soon in most countries, the lockdown situation will loosen up, and then the serving of documents will become more easy again.
Perhaps already this question, did you see in this 2-month period and perhaps even more in the last weeks, already an increase in cases that have been filed with the BAT, precisely related to COVID?
No, not really. Actually, in the first, I would say 2 or 3 weeks after many countries started to take measures, it was actually the opposite. It was quite quiet, understandably so, because people probably had other problems than filing claims. But after that, I would say the normal rhythm of new cases started again. And so far, we can come to that either later on or now, as you prefer. So far, we've not really received many Corona-related cases.
Did you get more phone calls, perhaps?
We did receive some phone calls, especially prior to the guidelines, and I think FIBA may even have received more calls than we have, from parties basically asking, what happens now? What happens to my contract? For example, my club is asking me to come back to country XYZ. I don't feel safe. What do I do? Things like that. Those were calls that we received. But I think maybe even FIBA, as I said, can tell you more about that than I can.
Okay, thank you, Heiner. We'll come back on the issuing of the guidelines. Finally, then I would like to ask Benjamin Schindler with FIBA whether or what the impact has been with respect to your role, obviously your known role, with respect to the enforcement of the BAT.
Thank you, Sébastien. First of all, thank you for the invitation, because for FIBA it's also a good way to be able to communicate it a little bit more widely about the current process we have. It's true, as Heiner mentioned, we received a lot of queries. Most of them were related to what would happen with the BAT securing process, but not only. Today I will be able to address this BAT queries questions that we received, but it's true that we have been receiving a lot of questions. So I hope that today it will at least answer some of the questions we received related to BAT securing, and I will obviously, as you mentioned, be limiting myself to this topic today, to the securing of BAT awards. As we had to adapt our process, obviously, due to the COVID-19. So having said that, you will understand that I will not be able to take an active part in the interesting discussion that will follow. I will reply to any question considering FIBA's position as an international federation and given our independence from the BAT. But still, it's important for us to be here and to explain a little bit what's happening right now during this crisis. So maybe before talking about the current situation, maybe I would like to briefly remind FIBA's role in securing the BAT awards for those of the attendant that do not know into detail what we do. So just briefly, so FIBA secures the decision of the BAT while remaining independent from it. Therefore, the winning parties can come to us, they can come to FIBA following a BAT decision in their favor from the BAT, and they can ask for FIBA's assistance to retrieve the amounts awarded by the BAT. This system has been working quite good over the past few years, and process is quite simple. In a few words, FIBA usually sends out a warning to the relevant party with a deadline to comply with the decision. Should the party of the bad award fail to comply within the given deadline, obviously we impose a ban on registration of new player if the party is a club. Let's take a club for example, because let's be honest, most of the losing party of the bad awards are clubs. So I'm giving this example. What do we mean by registration of new players? It concerns only international transfer, as FIBA has no jurisdiction over internal transfer within the same country, just for the sake of clarity. Now, after that, it's followed sometimes by other sanctions should the situation remain unchanged. We're talking about sports-related sanction or financial sanction. But this is really the second stage of the process. And it's worth also mentioning, because we've been doing that for the past few years, that right now we might assess the possibility upon request of imposing payment plan to ensure realistic payment of the amounts by the losing party of the bad awards if the specificities of the case allow it. So this is the usual process. I can say the COVID-free process of how FIBA is handling things. Now, as I mentioned at the beginning, FIBA had to adapt its sanctioning mechanism. Obviously, given the impact of the COVID-19 on the basketball stakeholders, as other panelists mentioned, the situation is hitting the stakeholders really hard right now. So since late March, FIBA proceed as follows. All the requests for assistance received since February have been taken into account. And however, FIBA decided not to send out any warning at this stage. So that's for the request of enforcement we received. I will explain a little bit why we went that way in the second part. Concerning all the deadline that has been set out by FIBA in the latest warning that we sent out before stopping to send any warning, for those warning which were not respected by the losing parties of bad awards, we did not sanction the losing party at this time. For the moment, no sanction have been imposed for such breach of the deadline. Concerning the fines, which is the second stage of the sanctioning mechanism, for the moment, everything has been frozen. No fines have been currently imposed. The same for the breach of a payment plan. We did not sanction the parties that breached the payment plan that we have been imposing. So this is the situation since beginning of March, I would say. So as I said, such adaptation was obviously necessary in light of the extraordinary pandemic situation worldwide, and obviously taking into account the financial impact striking right now. So this has been done taking into account that a lot of the stakeholders will have difficulties to obviously honor their contracts or any other financial obligations. So many affected stakeholders came to FIBA recently, and this is also part of what Heiner mentioned as many emails we received, following our decision not to pursue warning or to sanction during the pandemic, saying that all the amounts were due before the pandemic and that the COVID-19 is not related to the debts, and that it shouldn't have any impact or affect the right to obtain the amounts that were decided by the BAT. So obviously FIBA understands this frustration. However, it has been essential for us to assess the global situation at the time the sanctions are supposed to enter in force. So regardless of when the amounts have become due or when the decision of the BAT has been rendered. So FIBA needed to put on hold its usual sanctioning process to avoid imposing additional burden on losing party, of other words. This is obviously until situation returns to normal. But obviously, we understand that situation can also be difficult for the winning parties that are also struggling because of the situation. And we have to keep in mind that the system FIBA has in place is a system that is designed to sanction the losing party for its failure to respect the bad decision. So it was simply not reasonable for FIBA to take this path with every basketball stakeholder struggling at the moment, and to go ahead and adding sanction to stakeholders that are already facing a lot of difficulties. And we also have to keep in mind the approach that is usually the same approach FIBA is always having in mind when it's handling this process, even without the COVID-19. It's that we need to make sure that however decision we take, we need to have in mind that the club, if we still take the example of the club, need to survive actually the decision we impose in order to face their financial responsibilities. A lot of stakeholders come to me and say that sometimes we're too lenient, but it's also important to remind that if the club disappears, it's a lose-lose situation. No money will ever come back to the winning parties. So this is something we have to take into account. And now with the current situation we're facing, we are pretty much looking at this risk of having club disappearing. So we need to be careful when we think about sanctioning clubs that might be disappearing. So one other thing that is also worth mentioning is that even if sanction would have been imposed during the COVID-19, their effect would not be as constraining as usual. Obviously, with the league suspended and the club's primary focus on the financial surviving, a ban on international transfer of player would not have much sense at the moment in any case. Obviously, the suspension of the sanctioning system does not mean that the rights of claimants are not taken into account by FIBA. We're simply waiting for the sanctions to be realistically applicable in the current context. Obviously, all the process we achieved so far during the COVID-19 that I described today concerned the case we had to deal with from the beginning of the crisis until today. We're now living in a situation that evolves so fast and so quickly that we might have to adapt again shortly our process. But for the moment, it's the way we have been handling it. In any event, FIBA will have a case-by-case approach at the end of the pandemic crisis, because we need to make sure that the rights of the claimants are respected and that a reasonable payment scheme, if needed, allows the debtor to continue their activity. That's the main thing we want to achieve. So that was really the overview of the situation that I needed to mention today, because I think it answers a lot of questions that I personally received. It's good for us to have the possibility of communicating more about it and to let more people know about how we function right now. So thank you a lot for this opportunity and for this webinar, which is a really good initiative.
Okay, thank you, Benjamin. I'll have maybe just one question for you then. As many practitioners know, enforcing an award for a player, an agent, whoever, a club, that the party that won the award is usually most effective at the beginning of the season, because it is often linked to the lifting of the most used sanction, being a ban on international signings, international transfers. We hear that FIBA has taken the option during the beginning of this pandemic not to sanction additionally clubs that are already suffering. Do you have any timetable with respect to that? And in particular, is it something that is going to be reviewed in September, which is traditionally the period when teams, because I think 95% of the awards is most likely against teams, when teams try to lift those bans? Is it something that you can comment? Do you have a view on what the duration of this implicit suspension of sanction will be?
Well, it's a good question, actually, and it's difficult for me to answer that. Obviously, we'll have some internal discussion about it, but we have to keep in mind that right now we're not even sure of when the seasons will start, and depending on the countries, it might be totally shifted. So obviously, this will also depend on that. First of all, we'll have to probably evaluate how hard it hit various stakeholders, which is also why we'll have a case-by-case approach. But we'll definitely need to make sure that those clubs that did not suffer as much as some others and that can pay their debts will at least need to allocate some funds to do that. I mean, this is obviously a discussion we'll have. Nothing for sure right now, but this is probably the way we'll look at it. And there are so many parameters we have to take into account that right now are just unknown. So it's difficult to assess it. But we'll try to be taking this decision as soon as possible, and not after everything has been maybe begin in various league and all the transfer deadline elapsed, because obviously this would be different. But it's a good question and difficult to answer for sure.
Okay, thank you, Benjamin. Moving back to the guidelines, maybe, Heiner, I think we had already the explanation on why these guidelines were issued, because precisely there were so many questions addressed to FIBA and the BAT. Could you maybe very briefly say what the goal is that intended by those guidelines, and actually the guiding principles? What led the people who drafted these guidelines to the end product that we've seen?
As you say, I partly answered the question already. The many questions I think that FIBA and we received were basically a reflection of a desire for greater legal certainty, and that desire certainly not only existed in the basketball community. You can speak about that in any business sector at the moment, but obviously we had the advantage that through the short list of arbitrators, we could actually get the group together of those who decide and see whether they can agree on some principles that they think reflect the application of exequat bono to certain situations that either have already arisen in pending cases or we can surely expect to arise soon. So that was the trigger, and the goal is obviously to, by enacting these guidelines, to provide the market with some form of legal certainty, it being, of course, said in the beginning of the guidelines that they are just guidelines. It's not possible to, and also not the role of the BAT, to sort of make law by enacting a binding document that will be applied in every case, no matter what. That's not the idea of exequat bono. So obviously we could not come up with something that would do away completely with legal uncertainty. But what I think we could do is provide some guiding principles to the market with the goal of, first of all, everybody knowing in which direction things may go, and secondly, in order to facilitate amicable settlements, because, and that's already going into the next question that you asked, the guiding principles. I think everybody amongst the arbitrators and the BAT president and vice president was agreed, and probably most people in the community would agree that, in particular in times like these, it is, of course, the best solution of all if the parties involved in contractual disputes can get together, find a solution that is workable for both of them, and for the case to not even come to the BAT. So this was certainly one of the goals, to help parties in their settlement discussions. And obviously, if you're discussing settlement and have no idea what the adjudicating body would do, that's a very difficult discussion to have. So that was certainly one of the guiding principles and goals.
How did you, again, you don't have to answer if it's not possible for you, but how did you set the mark? There are, and what is of interest to many, I think, attendees today is of course the paragraph on the salary reduction, where apparently you decided to work with one threshold, the 2,500 net euro per month, above and below. How did you come to that?
Yeah.
Is it based upon statistics of claims with the BAT? Is it, I don't know, what's the reason for this mark?
Yes, maybe on a more general level first. Obviously, if you ask a lawyer, and there are probably many lawyers here in the call, what should be the solution for all cases that will come to the BAT? The instant reaction you will get is, well, it depends on the case. That's obviously true, but if we issued guidelines saying, just for you to know, it will depend on the circumstances of the case, then we could, just as well not have issued any guidelines at all, because the idea was to provide some form of legal certainty. So there was something that we felt we had to give to the market. Now the question, how did we get to what you find in the guidelines? First of all, procedurally, it was really just a conference call like the one we have here, just not with 186 participants, but rather with the president, vice president of the BAT, the arbitrators, and representatives of the BAT Secretariat, even though I should say the BAT Secretariat didn't actively participate in discussions. We were just listening, and it was really the arbitrators and the president and vice president discussing certain issues that may arise or have already arisen, and what everyone's views on that was. Now, this particular guideline number 16 on the salaries, why did we go, why did the arbitrators and president, vice president go for this two thresholds, or this two bracket system? The thinking was, and you will find it also in the guidelines, that in general, higher salaries should be subject to a higher percentual reduction in principle, which is something also known from many taxation systems around the world. Why? Because in lower salary regions, it's usually harder for the persons the person receiving the salary to accept a bigger pay cut. So that was the idea of introducing a lower salary bracket where a lower percentage cut would apply, and above that a higher percentage cut. Now, why is it 2,500? I agree with you, it could also be 1,000, or it could be 3,000 or 3,500. That was the number that everybody felt would, in most of the countries that we often see in BAT proceedings, be sufficient for players and coaches to make a living of. And you can still, obviously, since it's only a principle, adjust depending on the country involved, for example. But that's something that everybody felt was in line with the objective of safeguarding some minimal salary of players and coaches. And you will note that if you multiply 2,500 times 12, it happens to be 30,000, which initially was the threshold for what we called low value cases. Everything below 30,000 used to be cases that went into the award without reasons option. The threshold changed after that, but it was not so much because price levels rose, or we felt that now parties also above 30,000 don't have sufficient funds for paying for reasons. It was rather considerations of, do we have enough awards with reasons, for example, but that didn't really have anything to do with income levels. So that was certainly a number that played into it, but it was not the only consideration.
Okay, thank you, Heiner. Himar, perhaps, how did you welcome the guidelines? Have you been discussing them? Have you used them? Were they used in the discussions at the level of the EuroLeague in their discussion with the Players Union, the LPA? Thank you to give your view on that.
Well, I think that fortunately we are a club, an organization. I'm only here the last 4 years, but I think it was all life like that. We're not very, let's say, we haven't dealt with BIT situations many often. You know, I think it's only one case or a couple cases. I don't know. But I have to say that, of course, I think it's an institution that is well known in the basketball world. I have been in a little bit all of the sides of the table a little bit. So I think that a lot of people appreciate or take the guideline as something positive. I mean, the first impression was a surprise because I think it's the first time that something like that happened. But I think, I mean, we concretely were more, or we are addressing the situation with the perspective of the agreement between the EuroLeague and the Players Association. But I have to say that it's I would say not the same, but pretty similar. And I'm sure that it was something useful in order to make everyone have what you were asking before, have an idea of an overview that how could be the situation, or what Heiner explained perfectly is like whenever clubs and players or agents sit to negotiate. So instead that start from zero and from zero knowledge, because this new and a specific situation, they start, you know, with this guideline, they have something, you know, to put on the table and try to go from there. I think, as everyone says, every case has to be analyzed independently and different, but I think it was helpful. I think probably Stefano, that have deal with more clubs and more different organizations, have a bigger view of this.
Stefano, you have the floor.
Well, the guidelines were very welcome because it helped us to have a reference. The guidelines set a direction. Before the guidelines, and unfortunately still after the guidelines, we had to face so many different situations. There are countries, I'm talking mainly about Europe, of course. There are countries who has a strong social security system and allowed players to get unemployment allowance. And with all these countries, the situation was pretty much easier to be handled. But there is a variety of other different situations. Just a few, to my knowledge, just 2 leagues have reached a collective agreement, which is obviously EuroLeague with the EuroLeague Players Association and the Italian First Division, where a discussion led to an agreement between the League, Players Association, and Agents Association, and Coaches Association as well. For many other countries, the guidelines will give us the possibility to discuss with teams that one day to the other decided not to pay the players anymore because they were not able to work anymore, deciding to stop payments, deciding to stop contract, deciding on one way what would have been the future. Other countries have said, like Lithuania, for instance, a collective agreement established by owners of the clubs without any discussion or negotiation or any possibility of negotiation, with teams, with agents and players. Italian second division is the same as well. They decided, all owners, the league decided one direction, and basically we are forced to accept. In this regard, the guidelines are very, very important because, as said, a principle of equity and fairness. I agree to what Benjamin said earlier. It is very important for us that the system will survive and the club has to survive. I have been telling to all my clients, discussing the difficulties of the situation, that everybody has to suffer a little bit, but we have to be sure that club will not disappear, because otherwise the future will be obviously darker. And the possibility that, and I hope also the impact that the guidelines will have, is to help us in negotiation with teams and players to find a solution. No one really wants to have a dispute. We would like to have amicable solutions with all teams, but it's not easy. And I really think that the guidelines were really important for us to set a direction.
Stefano, did you see an increase since the issuing of the guidelines in settlements being reached?
Unfortunately, not really. We are using the guidelines as a reference. I also hope that those guidelines will be used as a reference from local arbitrations, that they will consider these guidelines as the way to handle the dispute. But for the moment, I still don't think that teams are willing to follow those guidelines and are in some way challenging us to start a BAT case and see what's up. One of the reasons we know is cost and the time that we will have to wait to get to an end. So in my opinion, teams are still trying to take advantage of the entire situation.
Okay, maybe one final view, a different view on that by Wouter. With respect to the guidelines, section 16 refer to the particular circumstances that, or the criteria that could be taken into account by the BAT arbitrator when assessing. Are there some tips and tricks, some giveaways that you would like to consider, whether it is for teams or for players? I would say the topics that are of interest in case this would lead to BAT cases, and what needs to be addressed by any of the claiming parties then.
Yes, as said, if things would come to a BAT case, it is possible that the BAT would reduce salaries with less than 20% or even with more than 50%. And in order to optimize your position before entering into the stage of BAT, there are some recommendations that we can give both to players, coaches, or clubs. A first one is that it's really recommended to engage in renegotiations. It's the primary message of the guidelines. And if you don't, it wouldn't surprise me that the BAT would punish the party that is not negotiating in good faith or not willing to enter into negotiations, to punish them not only on the merits, but also on the arbitration costs and legal fees, which can be an important financial part of a decision. Second, I think it's important to request or provide, depending whether you are a player or a coach or a club, evidence on certain things. The guidelines indicate a couple of elements that will be considered by the BAT. such as the financial situation of the club as a result of the crisis. The causal link will be, we deem, an important element to consider. Another element is the effort of the club to get all possible state aid. Another element is what will the club do with the money that is saved out by salary reduction? Will it be spent on big salaries for the next season, or will it be used to pay, for instance, infrastructure? It might have an impact on the decision of the BAT. What is also important is to have a good view and to request evidence on the financial situation of the player or the coach. Elements that will be taken into consideration is the cost of living, is for instance, the financial responsibility for relatives, or even the cash position of a player or a coach is mentioned. What I also think is important is to anticipate the next season in negotiations. As said, it is possible that contracts would overlap if the current season would be resumed and extended over the beginning of the next season for the current season to be completed. This is something to tackle in negotiations. And also in case there are multiple season contracts, it obviously will be a leverage to ask for or provide guarantees for the next seasons when negotiating the salary reduction for the current lockdown situation.
What do you mean by that, Wouter?
Well, as said, if parties find an amicable solution, then the BAT will consider that settlement on that as a final agreement, and the BAT will honor that. At least that's what the guidelines provide. They will not deviate from that anymore, even under an exequat bono. So if you find an agreement on the current months, it might be interesting to ask for or to provide guarantees for the upcoming months, for the further months, that the club or the player decides, okay, I'm willing to give in this, but as from the start of the new season, I want you to guarantee me a certain amount, regardless whether the situation went back to normal or not. So it's part of a negotiation there.
Okay, thank you for that. I think it's time to come to our last point before we address a few interesting questions that have come up. And the last one is, as if we haven't hit the bottom, is obviously the season 2021. We've been talking impact now on 1920. We've seen that the BAT has issued a tool that can be used. We've also seen that that tool hasn't resulted yet in that many agreements so far, and that quite a lot of stakeholders are still waiting to see how the end of the 1920 season will unfold. But we already see the premises of a potential new issue, which is the 2021 season. And obviously, the enforcement of contracts with respect to 2021, the continuation, if not of force majeure. Heiner, can you maybe fill us in on any reflection, any thoughts that are being given on that point already now?
I mean, there's one provision in the guidelines that does relate to the next season, which is what happens if in a country where a player or coach is currently playing, the season is prolonged, and that then basically leads to an overlap between that season and the season in another country where the player or coach already has a contract for the next season. That's the only provision that's currently in the guidelines regarding the next season. And I would say it was a conscious decision for the time being, not yet to go further into what may be in the next season, because as Benjamin already said, it's even unclear when the next season is going to start in many countries. It's unclear how the corona situation will develop until then. And you will have seen in the guidelines, there's a provision saying that the president, vice president, and arbitrators reserve the right to amend the guidelines depending on the developments and so on. So I think what we will see is, of course, everybody is closely monitoring the situation, and there may then be at some point an amendment to the guidelines touching upon issues that may arise for the next season. But I think at the time the guidelines were issued, everybody just felt it was too early. It was still too unclear what would happen in the future. So that's where we currently are, but it would obviously be very interesting also for me, because I will obviously take back all feedback that I receive here to the president, to hear what thoughts everybody has on problems that may arise in the next season, because that would then be something that we could discuss internally.
Well, for instance, we have seen already debates ongoing on contracts, new contracts that have to be signed now, so after the outburst of COVID-19, where teams are actually being very cautious about the date of entry into force of the agreements, because they don't know when their championship is effectively going to begin. I don't know if that is something, Stefano or Himar, that has already come across your agenda or your daily activity.
Well, yeah, it happened already. We have signed for 2 players a contract extension with the team, and everything was left without an answer. We did things just like the season will start as usual on July 1st, but nobody knows. So we were not able to provide any relevant clause to the contract because the situation is so difficult to preview. So we just did it in a normal way, and we will see what will happen. Players are aware of the fact that we may have future problems, and we'll see. We will see. On the other hand, I think one very important thing is what we already see coming from teams is the request of reduction on existing contract, and that will be an important issue for the future, because all the players that have accepted reductions today that still have existing contract for the next or more seasons will have to face this situation as well. But I think we can only live day by day right now, which is what we have been doing for the last 2 months, waiting to understand what can happen here, what can happen there.
Okay.
I think this is a key point in this whole situations. The mid long term, I think that we can not forget about that, and we really need to all address this situation, because definitely there's a lot of uncertainties now, and even more uncertainties for the future. We haven't started yet to plan the next season. Maybe we are in a little disadvantage with some other clubs that are already moving, but we don't feel we feel the responsibility, the secure the situation. So try to not speculate much, because as Stefano says, we need to live now day by day. And this is what we're trying to do, and being responsible with the whole situation that we have already in place for the future, because still there's a lot of, as I said, a lot of uncertainties, We want to honor the contracts, but we also would love that the sponsors honor their contracts. And honestly, they don't know right now. So it might happen that the clubs has a sponsor that this year already fulfilled all the obligations, financial obligations, but it wouldn't be able to do it next year, even despite they have a contract. Is what Benjamin and Stefano mentioned about the surviving of the club. We're not talking about clubs, but we're talking about now the sponsors, companies, regular companies, that if they don't survive this crisis, they are not going to be able to keep supporting our sports. And this is something that we also need to consider. Yeah, I think that that we need to try to again see this situation as a key point, the mid-long-term situations, in order to address the problems that we will face in the near future. Yeah, we're trying to manage that by now, day by day.
Himar and Stefano, does it mean that we will see much later negotiations of contracts than what we're used to so far?
I believe so. I believe so. What I have seen so far is very few negotiations, just teams asking informations, maybe trying to sign local players that we know has a different value, and there are less possibilities to sign them. For the rest, I see that some countries, I just want to be specific, France, they are trying to do something. There are teams doing already something. And one of the reasons is, I believe, the structure of clubs, but also the fact that the unemployment guaranteed by the government will help them to face the problematic situation. They know that if the country will, if the season will not start, the league will not start, they will have the possibility to keep using the unemployment to compensate the players, which is something that it exists only in a very few countries. Other leagues, like the Italian one, for instance, are really struggling to understand what to do right now. Most of the teams still don't know. Just maybe teams that have a solid ownership already know what kind of budget they may have, and they are planning already something. But signings are still far away, in my opinion. Yes.
Okay, thank you. I think that we have now time for a few questions which have been coming in. They go in various directions. Some have already been addressed. Maybe with respect to the overlapping seasons, an interesting one here, which says, with regard to the potential overlapping seasons aspect, why didn't BAT follow FIFA's recommendations that in such cases, priority should be given to the former club? Is it something that has been, can you comment on that, Heiner?
Yes, obviously the group was aware of the approach taken by FIFA. I think FIFA's justification for that is the stability of contracts. However, this apparently didn't occur as entirely compelling to the group, because you actually have two contracts. That's the very problem. You signed two contracts. They are both in force and binding, even though they have different terms. Why is it that the contractual stability requires prolonging the first one and cutting the second one, and not vice versa? So I think with the stability of contracts, it's difficult to argue if you have two contracts that are binding. And that's why I think the group didn't feel comfortable to say, okay, as a principle, the first one will be the lucky one, and the second team will have a problem because it will need to start the season without its players. And that's why they rather left that open, encouraged the three parties in that case to find a solution that works for them. And obviously, if they can't find a solution, then it may end up as a three-partite dispute. But hopefully, clubs between them and the player will be able to solve this, taking into account, for example, things like how many players does each of the two teams actually have where this is an issue? Would it be easier maybe for the old team to let the player go earlier because they have enough players on that very position? Would it be easier for the other team because in the beginning of the season, the schedule in terms of the opponent teams is not too tough? That would be things that I think the teams are better suited to take into account on a case-by-case basis.
Okay, then maybe I think still a bit for you, Heiner. Interesting with respect to agent issues. The first one relates to the BAT and not in particular to agent, but the question is being asked by an agent. And I quote, given that FIBA is being lenient on clubs and their ability to survive a decision, what about the cost of mounting a case and having to pay for both sides? In the light of knowing it will possibly take a longer time to both decide the case and for the losing side to pay, what is being done to help agents and team along these exact same lines? Paying to mount a case is a heavy burden at this time in light of no salary to players and no fees to agents. What the question actually is, does the BAT consider to lower the rates of the cost? I think that is the question.
Okay. Now, I could make it very easy for me and just refer to our rules, which say the fee is what it is and the fee is non-reimbursable. However, I think the thinking behind it, obviously I understand we're talking here about a situation where the guidelines say this is an extraordinary situation where basically, let's just simplify, clubs and players and obviously other stakeholders need to share a bit the financial burden that has been inflicted on the community by the crisis. Now, if you look at the BAT, I think there's a decisive difference. The reason why players and coaches and clubs in particular need to share the burden is because their contracts can no longer be performed. They agreed on the player playing and the club paying for it, and this no longer exists. This contractual equilibrium no longer exists. Whereas the handling fee or the advance on costs that's paid to the BAT, that is actually paid for services that continue to be rendered as they used to be before the crisis. And I alluded to it a bit earlier. Actually, we are having some extra work at the moment as well that we don't obviously charge for. Like, you will not believe how many hours went into these guidelines. You will not believe how many hours our case managers are currently spending on the phone with courier companies trying to deliver couriers in certain countries. You will not believe how much extra time it costs to deal with requests for extensions. So it's not like for us, it's exactly the same situation as before. But I think what is important for, in particular, players and agents, because they are usually the ones claiming, if you feel that the current situation is too difficult for you in terms of mounting money in the beginning, that without knowing whether you will actually be able to recover any of it in the end, I would say, but that's a general remark that would apply to any crisis or to any situation where you're not sure whether the debtor will be able to pay in the end. Either wait before you file a claim once, so to speak, the dust has settled a bit and you are in a position to have an idea of whether it's actually a good idea to bring a case against a club that may no longer be existing. And secondly, if you already have started a case, there's always the possibility to file a request for a suspension. If we've had that before in cases where during the arbitration, the club went maybe not yet into bankruptcy proceedings, but at least in a financially difficult situation, claimants have been asking for suspension, saying, I don't want to spend further time and money on the proceedings if I don't know whether after conclusion of the proceedings, the debtor still exists. So I think that is something that claimants can themselves do in order not to come into a situation where they feel like they're putting up money up front without getting any return in the end.
Okay, thank you. Then we have a question from a club's GM that asks about the compatibility or the relationship between the guidelines and applicable domestic law and decisions by government bodies that actually prevent any activity in the course of a contract. And so where the club is relying on national law, national measures taken by the government, and also, I assume, local social security law, that is not necessarily in line with those guidelines. How do you see that? Was that debated amongst the members of the BAT arbitrators?
Yes, I think you will see at one point in the guidelines also a reference to a local public health guidelines, that is, I think. So there is a reference in there, obviously, to local law. That being said, if the parties agreed, be it expressly in the arbitration clause or in the by reference to the BAT rules, which then refer to ex aequo bono, and if they agree to adjudication ex aequo bono, for a start, that means you dispose of the application of local laws. Now, that does not necessarily mean that local laws are entirely irrelevant. They may become relevant as a fact, in particular, if local law tells the club you need to shut down your operations, then just factually the situation will be different than in a country where it's actually possible for the club to participate in competitions, and for whatever reason they don't do it anyway for reasons not connected to local law. So I think as a fact that may play a role, but in general, the applicable law is ex aequo bono, and if local laws provide for something, then the arbitrator will need to look really case by case in what way that may impact his finding ex aequo bono.
Okay. Question for Mr. Schindler. Mr. Schindler said that FIBA had received many calls asking for advice on whether a player was required to return if he didn't feel safe. What advice was given? Was it just tied to the government restrictions on travel, or were personal feelings taken into account? I assume that's a question more related to players willing or wanting to leave, as already referred to by Stefano.
Yeah, well, as I mentioned before, I've been asked not to take any question or specific question, especially out of the scope of the BAT enforcement. Okay. But this might be something that we will be addressing in guidelines that might be published at a later stage.
Question then on agent fees. As an agent, what happens with an agency fee that had been scheduled to be paid at the beginning of the season and hasn't been paid yet because the agent has been patient? Would it also be subject to reduction according to the final amount of the player's salary after the new reductions being instated by the guidelines? Can maybe you say something about that? It's being touched at the very end of the guidelines, the issue on agent fees. I think the question here is, what if the agent fee does not concern the execution of the contract, but is only related to mediation services at the beginning? Is it normal, or is it to be expected then that there is still a mitigation of those fees?
Yeah, I'm afraid that's a question where I really can't give you a satisfactory answer. This provision on agent agreements in there, it was a conscious decision, not yet to take a decision in principle on this, precisely because when you look at different agent agreements, the scope of the agent services can be quite different. And that may, in fact, then have an impact on the answer to your question, whether or not a reduction should apply and to what extent. That may really depend on, is that just basically a finder's fee? Is that a service fee that is paid to the agent for ongoing services? And the arbitrators felt this was something that was really too difficult to put into a one principle fits it all approach.
Okay, thank you. This is a question that we as frequent BAT practitioners have received from numerous clients and potential clients. So I understood the reason why also. And just as the next one, and I think I can conclude with this one, which is, I think, also a very interesting one. Given that existing contracts have been reduced, I think it should read could be reduced. Has the BAT considered or decided how buyout clauses should be treated? If equitable solution is applied to both parties, a buyout for the next season should be reduced, as a player will not be receiving a full benefit of the 1920 contract if those guidelines were applied. I think it's a very interesting question also, which, yeah, I'm curious to see if you can comment on that, Heiner.
Unfortunately, as you say, it's maybe the last question. It's a bit unfortunate that for this one as well, my answer may not be satisfactory, because it's indeed a very interesting question, but it has not been discussed in the framework of the guidelines. So I cannot tell you what the arbitrator's approach would be to that, but I will certainly take note, because it is something that may very soon become relevant for players who have such a clause in their contract. So I'll certainly run it by the president.
Okay, Wouter?
Maybe this could also be an element to take into consideration by the BAT when a buying club is paying the buyout. Somewhere it shows that they have financial means to work on the next season. And so question is, would that have an impact on the reduction of salary of the current players with the buying club? Question mark.
Probably a question to me, I'm afraid.
Okay, we're going down too much, I think. Anyway, I hope we're coming at the end of this webinar. I hope we were able to, obviously, we did not provide all the answers because no one has them. It was not the purpose of this webinar. I hope we were able to tackle the most frequently heard issues and concerns. It was important for us to hear this from all stakeholders involved, and I would explicitly like to thank you, Benjamin, Heiner, Himar, Stefano, and Wouter, for their contribution and their presence. If additional questions, obviously, would arise, please feel free to address them to CRESTA or to any of the stakeholders here involved, and we'll see to what extent an answer can be given. I can only thank you for your massive presence today. It might, in post-COVID-19 times, be a good idea to have this kind of initiative and webinar more frequently. The BAT last year has taken the excellent initiative to organize I would say, physical seminar in Munich, which was also a huge success. Perhaps we can continue with this excellent tradition, hopefully have a seminar in person soon again, and to be able to see many of the basketball stakeholders. And in the alternative, why not 1 year out of 2 have similar initiatives like this? Again, thank you to everyone. Thank you to the panel members, and wish you all the best. Stay safe. Bye.
Bye.
Bye-bye.
Thank you.